Jerry, I see we have one question regarding, and I think you sort of covered this about are there any conditions or limitations permitted on approvals? And what if the applicant consents to the conditions? And you've already indicated that's okay.
Well, yeah, let's make very clear. Let's make it very clear that the applicant consenting to conditions, if we're talking about pre-existing conditions, that's fine. If we're talking about conditions with respect to that the applicant really will accept, that's fine. But if that applicant says no to any of those requested conditions, for instance, suppose the local community decides that they'd really like to impose stealth on the site when it comes in for the growth. If the applicant wants to agree to it, that's fine. But if the applicant says no, then you better find another reason that it's not entitled to 6409 fast track if you're going to deny.
So what I'm hearing to a certain extent is that if there are going to be conditions or limitations, they need to be in the initial approval process for the siting, rather than probably coming up at the modification or co-location.
That's exactly, Susan, that's exactly correct. And that's why the order is unfair. Because if 20 years ago somebody had said to you, understand that at some point this structure can grow as a matter of right without your approval and your conditions, then you might have been more suspect in what you permitted. Or you might have been more rigorous in the types of conditions and obligations you imposed on that permit holder. And so the real question is, will we learn from our past mistakes and make sure we do that going forward? And I hope that we do, because I think that the industry really needs to understand that things were pretty damn good before, and they keep asking for these additional capitulations, and it's going to hurt them, because at some point people aren't going to allow the deployment in the first place if they can justify the denial under 332C7.
So, and Jerry, this goes to the same issue really about buffers and setbacks. If you initially had as a condition a buffer for a neighboring residential area, or maybe setbacks of a certain amount, it certainly appears from the regulations that they can actually violate those conditions as long as it doesn't exceed the thresholds that are set forth in the rule for height and width. Is that correct?
I think that's correct. I think that there's a bit of an open argument as to boundaries. Can I argue that the boundary of the facility is really 15 feet inside because that was the setback and that was the condition that everybody agreed to? And I don't want to surrender that argument, but it's certainly in play.
We have another question about if a tower is approved, then increase the height. Can it be done a second time, or is the application?
I'm not answering that question, Mike. Scott, you weren't paying attention. I talked about that. No, it's a marvelous question, and it's something that we worked on very hard. And the answer is, that's why I went through that whole bit about the size of the, if you look at slide 25, and I don't know if I can do that quickly here. If I can, I will. Mike, on slide 25, the baseline for measurement, the height is measured from the dimensions of the tower as of February 22nd, 2012. And so if I come in, if my tower is 100 feet and I grow it to 105 the first time, and I can come back in and grow it to 110, but that's it. That's it. Or I guess technically I could grow it to 125 because if I'm at 105, I can grow it for an additional array. But then I'm done. So we have a baseline in terms of height and growth. It can't just keep on growing and growing and growing. I hope that answers your question.
Our next question, Jerry, is really an interesting one. It's about whether the 60-day rule applies to both modification approval and building permit issuance. Are those two separate processes?
No. My dear friends in the city of Atlanta asked me the exact same question. I believe that the way that the commission doesn't take all this specifically into consideration. They simply say that you have to provide a build or no build authorization by day 60. Now, I mean, I guess I would be talking to people about the additional time, but there are real challenges here. There are real challenges for the community when you have sort of these processes being sequential, right? You may need to look and examine your process and see whether or not there are ways that you can short circuit or shortcut it. So this is not easy. I love these questions, and Jeff Hayward, I love this question because it's bringing to light that this is not a ho-hum order. This will cause dramatic interruptions in the way things are done.
I have another question that occurred to me as we were going through the materials, which is whether you can put a deadline on submission of material from the provider if the application is incomplete, or can it just sit out there for 2 years and then they come back to you and start the clock again? Should we give them a reasonable amount of time and then make them start over if they don't get back to us?
What I would do, and again, I know that that's a real life example. I mean, people do that. That's what's so friggin' infuriating is when the industry came to the commission and talked about all these delays, and you go back and you ask the jurisdiction what happened, and typically it's because people sat there and never got around to finishing their applications. If I were going to do that, and that's a really terrific idea, Susan, if I were going to do that, I would do that across the board. I would, again, have a non, what's the word? Non-subjective standard, right? So I would have a non-subjective standard that says all applications for permits within this city, must be completed within, within 180 days of any request for additional information or such a permit application shall be deemed denied. Yeah? Mm-hmm. Or withdrawn. And again, I think if you show you're not picking on them, now I think you'd have a hard time if you limit it to 6409, right? Anyone asking for authorization under Section 6409 of the communication, I think that would be trouble because you could be argued that you're singling them out. But if you do it broader, I think that you're in a defensible position, or a more defensible position.
And this is another question just for me, which is slightly off topic, but also I think of interest, which is whether there is any chance at all that the FCC might recategorize internet services as a telecommunications service, as they should have done originally, rather than some sort of nebulous information service. Thoughts?
Right. Susan is asking me, where do I think that the FCC will come out on the issue of net neutrality and whether or not it will apply Title II obligations and characterizations to broadband services, regardless of whether it's provided by a cable operator, a telephone operator, or a wireless provider? And I think the answer is yes. I do believe that they will impose a Title II, and that will be interesting for a whole lot of reasons. But I don't think that gets us off the hook whatsoever in terms of complying with 6409. It's not that the industry will be so aggravated and concerned about the commission that they'll forget about us.
Jerry, this is Lou. I have a question regarding these small cells that we're starting to see some of our cities approached by companies that want to put up the small cells in their downtown areas, and they're coming to them with proposals saying, oh, look at this lovely lamppost we want to put in your downtown area. And, I think some of our cities are wanting to be accepting of these so their citizens can have more coverage. But my concern is they're going to get these approved, and then these lovely lampposts are going to grow taller and wider. Would that be
Luke Comer, if I didn't come off as sexist, I would give you a kiss, because that's the exact point that we wanted to make. I'm not telling any local government in Georgia what it should do, but I want them to make an informed decision. And you're absolutely correct that if they permit these things, they can grow to be 10 by 6. So now, here's the other question, and this was in sort of possible ways to sort of reduce the the negative impact. Is there anything that would prohibit? And I'm trying to think of the Schaefer Act and some of the other Georgia laws. And I apologize, folks, I'm not a Georgia expert. But is there anything that would limit a local jurisdiction from saying to them, look, how about this? How about we simply do a franchise? And I'm not going to give you a permit for any of these individual sites, but I'm going to give you the ability to deploy these things as part of a franchise. And you agree that they'll all meet these various codes, and we'll have a team work together. So that it takes it outside of the wireless ordinance, and it makes it a more of a right-of-way franchise ordinance, and you might be able to avoid the threat that way.
Interesting. And I take it the other way would be when they do the initial application would be to have them show what it could be with modification so that the public sees what's being approved.
Susan, you're absolutely correct. I'm not trying to hide the ball here. Excuse me. I didn't mean it that way. Again, I think that the community has a right to know what they might be looking at some time in the future. What you can't do is you can't make them agree. You can't make them agree with your regulatory hat on. You can't make them agree that it won't grow. That's not permitted. Now, if you do it as a proprietor, right? You're doing it as the owner of the lamppost. Yeah, that you can do. And so you do with your real estate hat what you might not otherwise be able to do with your regulator hat.
Very interesting. Very interesting. Well, I don't see any more questions at this time, and we're just about to the end of our time. But Jerry, I would like to thank you very much for this very illuminating and educational presentation. You've given us all a lot to think about today.
Well, I'm absolutely thrilled to have been on, and you guys you've been very kind to me. Every time I come to Georgia, I understand that my middle name isn't Yankee, and I won't say what Susan says the first name is, but we'll let it go.
Thanks again, Jerry.
Bye, everyone.
Bye.